You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Not currently.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Right from the start, it feels routine, lawyers announcing appearances, preliminary exams being scheduled. But don't let that fool you. This docket is about to expose missed appearances and serious consequences. Stay tuned as ordinary roll call turns dramatic fast. Subscribe for more dramatic breakdowns of real courtroom action.
And good afternoon, Your Honor. Jamil Kuja appearing on behalf of Montrez Root.
Good morning, Mr. Kucha. How are you?
Good, nice to see
Your name, sir?
you. Montrez Root.
All right. And what are we doing today?
Judge, we were asking this matter for a preliminary exam, please.
All right. Is all discovery complete?
Yes.
All right. People have their witnesses available? People have their witnesses available the 3rd?
We'll do our best, Your Honor.
Preliminary examination in person will be set March 3rd, March 3rd, 2026, 9 a.m. before Judge Perry.
Okay. Thank you.
Thank you. Bond will continue.
Thank you, Judge.
Thank you, sir. Court calls case, People versus Koisha Pipkins.
Mr. Pipkins is present on Zoom.
Ms. Pipkins, can you say
Yes, I
your
am.
name, please?
Yes,
State your name.
Koisha Pipkin.
Okay.
Koisha
Just-
Pipkin.
One more. Just adjournment so I can read this.
Probable cause conference will be adjourned to. You had previous, did you just get into this? Or
Yes,
just
yesterday.
look up? Okay. March 19th, 2026, 9 a.m.
Thank you.
Bond continued. Thank you, ma'am. Court calls
Thank
case
you.
of People versus, you're welcome. Court calls case People versus James Thomas.
Good afternoon, Your Honor. Raymond Cook with People. Afternoon, Your Honor. Dan Garrett on behalf of James Thomas. What's your name, Dan?
James Thomas. Thank you, sir.
We also just substituted in yesterday or the day before. Would ask for an adjourned PCC, please.
All right, 12th or 19th, who better, sir?
19th, please, Your Honor.
Probable cause conference, March 19th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case, the People versus Francisco Cazeta, is it Laretta?
Assistant Public Defender Shanazi Carey, I can really on behalf of Mr. Cazeta Loretta. Can I just check outside?
With this bond violation report, I doubt it's here, but we can go ahead and check if you want.
Doesn't look like he's here, Your Honor.
I'm
I
shocked. Go ahead, I'm sorry.
for the record, Your Honor, I have spoken with Mr. Cazeta Loretta. He assured me that he would be here today, and we had what I thought was a very good explanation to provide to the court today for the voluptuous bond violation.
It's like 3 pages.
It is. He was asking to be on Zoom, Your Honor, and
Sure he was.
I told him that the court, I was not even gonna make that request because I knew it would be denied. He does live very far away. I would ask the court to pass.
He
the
lives
matter.
very far away?
Yes, he does, Judge, in Kentwood County. I don't know where that is. Grand Rapids, yep.
I knew that. I knew.
So,
Bench warrants will issue for defendant's failure to appear. Nice argument.
thank you.
Bond $25,000, cash surety. That warrant will issue immediately.
Your Honor.
I don't know why she looked disappointed. Did she really expect anything different? Court calls the case, People versus Lawrence Ransom.
Assistant Public Defender should not be carried out concealed, Your Honor.
Is Bishop responsible for getting your people here? No, is Bishop responsible for getting your people here? Because if he is, he's not, don't walk out on me yet.
I take full responsibility for everything, Judge. I have no explanation to the court. I do apologize.
Bishop had an explanation, but he left.
He left. He ran out of here. I was doing so well this morning, for the record.
Well, not really.
Let the
But
record
okay,
reflect.
Doing great, right?
you were doing better than you are now. I'll give you that. Bench warrant will issue for defendants to appear, bond $10,000, cash surety. That warrant will issue immediately. Court calls the case, People versus Devon Reed. And continue with the streak, Mr. Gaddy.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Reed. Your Honor, I've reached out 7 ways to Sunday. I don't have any explanation.
Bench warrant, $10,000, cash surety. That warrant will issue immediately. Court calls the case, People versus Mapendo. Raditerciri.
Ready, Judge, to assistant public defender on behalf of my client who is on the way up, Judge.
Oh, okay.
Please state your name when you get to the podium. Say your name.
I'm a friend of Tyson.
Right. Thank you, Judge. I've turned to the hand of the bar. I've turned to the court at Green Sheet. We spoken to Mr. Childers about a resolution. We're very close to a resolution. We have a brief adjournment. I think we'll get this matter resolved.
Well, 2026, 9 a.m. bond continues.
Thank you, Judge. March 12th. Call.
Court calls case, People versus
Wait, somebody back there. I'll get it to you.
Jalen Seal.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Steele. Your Honor. He is approaching, he's with my truck. Can you grab him? He is approaching.
Here?
He is here. He's in a room with Mr. Green from our office. Your Honor, if I might just have a second.
Your name, sir? Jones. All right.
Your Honor, we'd ask the court to set this matter for a preliminary examination.
Discovery is complete.
Yes, Judge. To the best of my knowledge.
People have their witnesses available the third. Preliminary examination in person. March 3rd, 2020. 9 a.m. before judge. Fresh hour.
Thank you, Your Honor.
Thank you, Judge.
Bond continue. Court calls the cases of the People versus Tasha Shiner.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Shiner, Your Honor. She's not here that I can find. She was released, it looks like on February 11th. There's a bond violation. I don't have contact information for her, so I wasn't able to reach her. She was up in Alpena, then got brought down here, was released on the 11th, and I saw the bond violation yesterday.
Yeah. Bench warrant will issue. Bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Here's a pivotal legal moment. A no contest plea to misdemeanor stalking means the court treats it like a guilty plea for sentencing. Count 1 gets dismissed, but probation and mental health conditions remain binding. This is strategic damage control. Would you accept probation over risking trial?
Case People versus Charlene Smith.
Your Honor, Raymond Cook to the people.
Good afternoon, Your Honor. Joy Gaines, Senior Assistant Public Defender. Your Honor, I've called Ms. Smith's name in the courtroom and in the hallway
And what?
with no response, Your
No
Honor.
response?
That's
Shocked. You know what? I think she's with Miss Akinrubi's class. It's got a bond violation also. So bench warrant will issue bond $25,000. Cash surety, that warrant will issue immediately. Court calls the case of the People versus Jordan Smith.
Assistant Public Defender Jay Bellinger on behalf of Mr. Smith, who appears via Zoom, Your Honor.
Sir, please state your name.
Jordan Smith.
The court has before the plea form that indicates that the defendant will be pleading no contest to the charge of count 2 of stalking. The misdemeanor punishable by up to 1 year incarceration. On a successful plea to that count 2, count 1 would be dismissed. There's an agreement that the defendant will continue mental health treatment as recommended by probation and defendant's mental health professionals. There's a sentence agreement for probation for a term of 5 years. That's the court's full understanding of the agreement.
That is our understanding of the agreement as well. Mr. Smith, is that your understanding?
Yes, it is.
Mr. Smith, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So,
I do.
state your name for the record, sir.
Jordan Smith.
All right, sir, it is this court's understanding that you are going to be pleading guilty to or pleading no contest to the charge of stalking. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs, and up to 5 years probation. You understand that, sir?
Yes, Your Honor.
Do you understand what a no contest plea is?
Yes.
All right, 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right. Basis for the no contest plea.
A fear of potential civil liability, Your Honor.
All right. So, sir, to the charge of stalking, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form or caused one to be signed on your behalf?
Yes, Your Honor.
Do you have any questions regarding any of those rights?
No, sir.
Looking at paragraph 5, those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights that are contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Not currently.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes.
Has been provided and has reviewed Ann Arbor Police Department report for their case number 25-5 4183. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon the review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if I accept your plea, between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that, sir?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
March 9th at 8:30.
March 9th, 2026, 8:30
March
before
9th,
Judge Perry. Yes,
Thank you.
but make sure you contact 15th District Court probation.
Yes, sir.
Thank you, Your Honor.
Bond in this case will continue.
Oh,
Thank you.
Your Honor. Your Honor, if I may briefly address part of that bond. After speaking with my clients, my understanding that he's been on tether since November 25th of 2025 with no issue. He is seeking to have that tether removed at this time, if that's possible.
I'm not going to remove it I'd leave it to Judge Perry's discretion as to what she wishes to do.
Okay, you hear that, Mr. Smith?
Yeah, I heard that.
Okay,
All right, thank you.
all right, thank you.
You're welcome. Thank you, Your Honor.
Yeah. I always got to make sure that it's weird thing. Let's call the case of People versus Matthew Smith. Is that right?
Yes. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Would you state your name for the record?
Matthew Smith.
Your Honor, we are requesting an adjournment in this matter so that we can have an opportunity to review some media. We also are asking, pursuant to the report received from Community Corrections, that Mr. Smith be able to test, use an oral screening as opposed to a urine screening.
Does he have a medical marijuana card?
Yes.
Yes, he does.
Why didn't you provide it to them? Do you have it with you?
I don't. Miss Dozier has it on file. I spoke to her this morning. She said she had to put a copy of it in there.
This exchange is tense. The judge lists multiple missed or refused tests, December, January, February, creating a credibility problem. Defense argues confusion, not defiance. That distinction matters. Judges look for patterns, not excuses. When compliance slips repeatedly, trust erodes quickly. Is this oversight or accountability catching up?
Where is your card?
I'm sorry.
Where is your card?
I think it might be in my backpack in the car.
I don't see on here where she's indicating that you have presented a medical marijuana card to her. Well, first of all, in regard to your request, I'm not going to change it because he's missing tests.
Your Honor, it was my understanding from reviewing the report that she's marking them as missed, but actually he's appearing but not able to provide a sample.
There are two things. One, so on December 16th, January 2nd, January 12th, January 22nd, and February 12th. The results are missed, but they are marked that he's unable or refused. On December 24th and on January 30th, it's missed, but not he just missed a test. You see if you can get through to Miss Dozier, see if there's a card.
It is. But I did talk to her this morning. She said she had a yeah, it should be in
Your Honor, Mr. If we could pass, he will either go look for it, or if you would like for us to stay here, we'll see if his sister is available
Pardon?
to go into the car to look for his medical marijuana card.
That says yes with an issue date of 5/8/24 and an expiration date of 5/8/26.
Okay, we have it.
Thank you, Your Honor.
He's good. All right, you want an adjournment on this?
Yes, please.
I'm not. We can change his testing to a swab, but I don't want any missed tests. You understand that?
Yes, sir.
I'll adjourn probable cause conference then to March 12th, 2026, 9 a.m. Bond will continue.
Hey, thank you, Your Honor.
Court calls case, People versus Danielle Stewart.
And Assistant Public Defender Jay Bellinger on behalf of Ms. Stewart, who should be in appearance via Zoom, Your Honor.
Hi,
Hello, what's your name?
Danielle Stewart.
Your Honor, we are close to an offer, to a resolution on this matter. There's just some nursing licensing stuff that we need to check in on. So we were just asking for a little time to do that.
March 12th, 2026, 9 a.m. Bond
Right.
continue.
Thank you.
Have a
Thank you.
great week without me.
It'd be hard. Thank you.
I know, you'll get through it.
Take care.
Thank you.
Court calls case, People versus Lakrita Thompson.
As a public defender, Chelsea Virgil is with and on behalf of Lakrita Thompson, who is approaching. Thompson, please state your name.
Lakrita Thompson.
What are we doing?
Good morning.
We are asking to adjourn for Ms. Thompson to review her discovery and for a plea discussion. But also ask to address a bond condition when the court is ready.
Probable cause conference will be adjourned to March 12th, 2026, 9 a.m. Yes, that's the bond.
Your Honor, regarding bond, Ms. Thompson is on a scram tether currently, and she's asking to switch to a SoberLink device. She's having some health issues. She has a note from Trinity Health stating due to the health issues with her legs, she needs to wear compression socks. Due to her varicose veins. She is on her feet all day at work. She works full time. Miss Thompson.
That's what the medical indicates.
Yeah, so this note from Trinity Health states, so one states she was seen at the emergency department due to longstanding history of pain due to varicose veins. She needs to wear
This is from my doctor.
compression socks, and then
We
this-
will switch, that's all right. We'll switch her over to Silverline.
Okay, thank you, Your Honor.
Her bond will continue. We'll prepare a new order. She can be switched over to the Silverline testing test.
We appreciate that. Thank you, Your Honor.
Thank you.
You're awesome.
Court calls case People versus Willie Thorne.
Judge, Workshop fees to Assistant Public Defender on behalf of Mr. Thorne, who I believe is on Zoom. Mr. Thorne, please unmute, state your name for the record.
Mr. Thorne, can you unmute?
My name is Willie Thorne.
Thank you.
Thank you, Judge. I believe Mr. Cook is going to speak to the complainant in this matter and let us know. Judge, I was gonna adjourn it, but just put Mr. Cook, we're gonna set it for exam and move it forward, if you don't mind.
Discovery is complete.
Come on now, the judge.
People have their witnesses available on the 3rd.
Do our best, Your Honor.
Preliminary examination in person, March 3rd, 2026, 9 a.m. Bond will or before Judge Perry. Bond will continue.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls the case of the People versus Get Tootle.
Good afternoon, Your Honor. Raymond Cook for the people.
For the judge, Workshop fees to Public Defender on behalf of Ms. Tootle, who I
think, hang on, she's in Zoom.
Okay.
Ms. Tootle, can you state your name, please?
India Tootle.
Thank you.
Thank you, Judge. I believe Ms. Gaines is handling this file. She indicates that Ms. Tootle would like her exam date, please, Your Honor.
She wants an exam.
Yes, Judge. To my knowledge.
Discovery to your knowledge is complete.
Yes, Judge.
People have their witnesses available the 3rd.
Do our best, Your Honor.
Preliminary examination in person, March 3rd, 2026, 9 a.m. before Judge Freshour.
Thank you very much, Judge.
Bond will continue. Thank you. Court calls case People versus Michael Umber.
Another plea hearing, but technical trouble stops everything. If the defendant can't hear clearly, the court won't risk a flawed plea. That's procedural protection in action. Rather than push forward, the judge adjourns. Due process matters more than speed, especially with OWI second offense penalties looming.
The plea.
Oh.
Hello?
Hello, Mr. Umber, can you state your name?
Yes, Michael Umber.
All right. I have before me a plea form that indicates that the defendant is going to be pleading no contest to 2 charges. One of operating while intoxicated, second offense, a 1-year charge, and also a count 4 of disorderly person, which is a 90-day offense. Upon his successful pleas of no contest to counts 2 and 4, counts 1 and 3 would be dismissed. That's the court's full understanding of the agreement.
That's our understanding as well.
All right, very good. Sir, remember,
Yes.
Can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God, sir?
I do.
All right, state your name for the record.
Michael Umber.
Okay, Mr. Umber, I see you leaning into the camera. Are you going to have a problem hearing me?
Yes, I am.
Oh,
And
okay.
I
You're going to
turned the
have
volume up on my phone and I'm still having problems.
Okay, all right, let's do this then. I'm not gonna, if you can't hear me, If I set a new date, do you think you can get down here so we can get this done?
What's the date?
I can set it for next week or the 5th. Which is better for you?
No, let's do it next week.
Next week? Okay, that's
Yes.
fine. So I will adjourn this to February 26th, 2026, 9 a.m. But check with your attorneys as to what time block you'll be in. Okay, Mr. Ember?
Yes, sir.
All right, we'll see you then. Thank
All
you.
right, thank you very much. Thank you, Chelsea.
What? What? Standing does not help. No, you're not. Do you have a file? You're setting me up. You just got the files because she asked. They were supposed to be long gone. I don't know. What?
Nothing.
I'll decide in a minute. No, do not stuff those in there like I'm just gonna hang. Court calls the case, People versus Sarah Ward.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Ward, you're in.
Your name?
Sarah Ward.
Thank you. Requesting an adjournment.
Yes, Your Honor. We're asking, we're in discussions with the people.
Probable cause conference will be adjourned March 12th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls the case. People versus Asnan Wasim.
Michael Gaddy, Assistant Public Defender on behalf of Mr.
Your name, sir?
Asnan Wasim.
Thank you. You're requesting an adjournment?
Yes, Your Honor, we're asking to adjourn this matter to see if we can't resolve it with the people.
March 12th, 2026, 9 a.m. Bond continue. Court calls the case. People versus wife.
Take that one.
Assistant Public Defender Kelsey Ridfield with and on behalf of Andrew White. Your
name, sir?
Andrew White.
Thank you.
We are asking to adjourn to continue a plea discussion.
Probable cause conference, March 12th, 2026, 9 a.m. Bond continue. Thank you. Court calls case, People versus Tony Woods. Tony Woods. It's a PD case. It was assigned to Miss Pate. She's not
Michael
here.
Gaddy, Assistant Public Defender on behalf of Tony Woods. They're checking the hallway, Judge.
Is that Bishop checking the hallway? I don't trust him.
Actually, it was Felon. No, it was checking the hallway.
Okay, your office let us know that he's actually in Kent County MDOC.
Yeah, of course, Judge. We asked to adjourn this matter, Judge, to rid him out, or to do a video writ.
in Kent County.
So is he in the Kent County Jail and then books?
We have it as Kent County, he's in DOC in Kent County.
Yes.
Sure.
And so I'll adjourn this out to the 12th,
Thank you, Judge.
2026, 9 a.m. Bond continue.
I do not have an area controller in that area. We're waiting for one to sign.
Whose case is it? Yeah. Is your client here that needs the interpreter?
Yes, Your Honor.
So that one is
Yes, he is.
on time,
On time.
unlike the others who's shown up at whatever God knows time and just wants me to call the case. Are they all in the courtroom now?
Yes, they are.
Well, I'm gonna take a recess. I'll come back out and I'll make a decision whether I'm gonna hear it. They had me wait.
From no-shows triggering instant warrants to negotiated pleas and bond debates, this session proves court waits for no one. Preparation and compliance make all the difference. When you're absent or unprepared, the consequences are immediate. Like, comment, and subscribe for more shocking courtroom stories and breakdowns.